The A team. Thank you, Marissa. Good afternoon. This is Judge Elisa Bettis presiding over the 210th District Court criminal docket for September 23rd, 2025. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Let's see, Mr. Carmona, you're the one with the camera on. So who is this at the annex?
This is Peña Jose.
Mr. Peña for Mr. Carmona, Judge.
Oh, okay. Thank you. Thank you. Thank you. Okay. All right. Calling cause number 2024 0D06430, State of Texas versus Jose Alvaro Peña Ramirez. May I have announcements? We also have 2025 0D04751. Each case is set for a bond hearing today. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Good afternoon, Your Honor. Omar Carmona on behalf of Mr. Jose Alvaro Peña Ramirez, ready for the bond hearing, and my client is present via Zoom from the detention facility.
Thank you very much. We are set for bond hearings. What are the bonds in each of these cases?
Let me check, Judge. I should have had that one.
You know, we have so many today, and I'm usually really good about prepping.
Your Honor, it's 110,000 on the one ending in 64. I can't see the rest of it. 64 something.
Mm-hmm.
And the 4751 is 150,000 cash or surety.
Are either of those split?
The 110,
Mm-hmm.
it's 10 and 100.
Okay. All righty. Mr. Carmona, you may proceed.
Thank you, Your Honor. And if I may just proffer the
Yeah.
following. I went to go look at the bonds, and I took myself off the page. I
messed everybody up. Okay.
I'm sorry, Judge.
Take your time.
But I can say that Mr. Peña who's been in custody for quite some time, Your Honor. He's been in custody I was on a sexual assault case, Your Honor, on the 2024 case. Since he's been in custody, Your Honor, a new case was indicted. My client wasn't released at that time, but now new allegations have come. And I only say that to highlight my concern over this complaining witness. I believe, Your Honor, that the state doesn't have sufficient evidence to convict my client at trial based on the sex case. Now, again, we're going to get into that at a later date if we have to go to trial. But based on the facts, Your Honor, this was a delayed outcry, Judge. DNA tests were done. My client did not come back positive on any DNA kit, Your Honor. My client is a lifelong resident of El Paso County, Texas. He lives on Limerick Street with his family for the last 30 years. They've been at that same address. I also noticed that the complaining witness in this case did put that address down on her victim's info. However, she does not live at that address, Judge. My client would be living on Limerick with his parents and no one else. Also, Your Honor, my client has two children, 21 and 15. He does pay child support for the 15-year-old. His 21-year-old child is attending university here in Texas. Your Honor, my client is gainfully employed. I will get you that information right now as soon as I pull up that page. It is he is a diesel mechanic. He is self-employed. He makes about $41 an hour. My client graduated from EPCC with an associate's in as a diesel tech, Your Honor. And given just what's gone on with this case, my client again was sitting in jail. And next thing you know, we have new indictments. And I believe that's because the state has met with this complaining witness. And I believe the complaining witness to be changing her story. For those reasons, Judge, we're asking this court to consider a reduced bond, split PR, split surety, with the strictest conditions. My client has no need to see the complaining witness in this case. So I am not concerned for her safety, Judge. And for those reasons, we're asking to consider a bond reduction. Thank you.
Thank you. Mr. Garcia?
Yes, Your Honor. So at this point, Your Honor, the state is opposed to any bond reductions. That's because Just 2 years before these new indictments of 1, 2, 3, 4, 5 felonies, Mr. Peña just finished a 2-year TDC sentence back in 2022 for another assault family violence. Before then, Your Honor, he was completing probation for a DWI third or more. Before then, he did another DWI conviction back in 2012. And the history goes on until year 2003, Your Honor. He has a long history of repeat offending, Your Honor. And again, just right after he completed a 2-year sentence back in 2022, 2 years later, he picked up 5 new offenses, one of them including first degree, Your Honor. Because of that and the safety of the community, I believe the bonds are adequate as they are, Your Honor.
Okay, so, I have an extensive prior history. You said he's been to TD. On that last DWI, that DWI third, Mr. Garcia, did he complete probation successfully?
He actually did 2 years TDC, Your Honor.
Okay, so he didn't. So the PSR, aside from the, okay, so that DWI third was in 2022. I saw some probation revocations in here. The PSR is 27 pages. It's a lot of history. What resources does he have towards a bond? I believe you're appointed, aren't you, Mr. Carmona?
Your Honor, yes, I am, Your Honor. We were asking the court, the most he could probably come up with cash would be in the neighborhood if his family could come up with 5,000.
So let me see. What are the relations in each of the cases? So we don't have the same complainant, do we? Or do we?
We do, Your Honor. We do.
Okay.
It's Priscilla Garcia, I believe. Let me see.
So same complainant in 6430 37, and the alleged date of offense on the assault.
They're all October 13th of 2024.
Oh,
And Your Honor, they knew each other 3 weeks prior. They met each other 3 weeks prior to that.
okay. Okay, so I am going to, anything else?
Not from the state, Your Honor.
Okay,
Nothing further, Your Honor.
I'm going to grant the request to reduce bond, but it's not going to be by a whole lot, Mr. Carmona. Frankly, on 6430, the only change is going to be the cash surety portion is now going to be $75,000. And on 4751, we are going to split that 75,000 cash surety, 75,000 PR with the restrictions, obviously, of no contact with the complainant. I'm sure that's part of the PR conditions on the other case. We are going to institute, we're going to do once a month reporting. Both of these need to be consistent so we don't have any discrepancy. If there's a JMAG PR order on 6430, we need to change that. So we're going to do once a month reporting in person to PR bond, no illegal alcohol subject to testing. We are going to put a curfew from 10 p.m. to 6 a.m. No contact, no going to the place of business or residence of the complaining witness, no indirect contact, no messages through third parties, any of that kind of business, no emails, things like that.
Yes, Your Honor.
Let me think.
Your Honor, if I can get clarification, he's currently reporting to, or the order is for him to report bi-weekly. So you want to switch that to monthly?
Yeah, monthly is fine.
Okay.
Monthly is fine for me. So if we can put them both like that. Let me check something. Hold on. Is there any allegation of alcohol in either of these incidents?
Let me check, Judge. No, Your Honor.
All right. I kind of want to put an alcohol monitor on him, but all right, if there's no allegation of alcohol being involved in these incidents, then we'll leave that out. And of course, commit no new offense. He may not leave El Paso County or change his place of residence without court permission. And of course, appear for court. So that'll be the order for now. Okay.
Thank you, Your Honor.
Anything else that you need on this hearing? I think we
No,
were
Your
just
Honor.
on hearings. Perfect. Thank you
May I
very much.
excuse
You may. Have a good day.
you as well, Judge. Thank you.
Where are we going next?
Oh,
Mr.
thank you.
Nanez?
Judge, on page 14, Angel Martinez for Mr. Nunez. Annex, can we get Martinez?
Wow. Literally the next PSR I have. Good afternoon, Mr. Nunez.
Good afternoon, Your Honor.
All right. What's his bond at?
That's
So
enough.
$1 million split bond, Judge, 75 PR, $1 million corporate cash surety.
I'm sorry, how much?
$1 million, it's $1,075,000 with 75,000 PR and $1 million cash surety.
Okay.
Might have a 3-page PSR, but it's got a high bond. Have
I'm
we
sorry, is this
done a
the
bond
same
hearing
one?
before?
Yes. Is this the same one?
This is Martinez Angel, sir.
Give me a second. There is. We've been here before. All right. Calling cause number 2025-0D02794, State of Texas versus Angel Maximo Martinez. May I have announcements, please?
Jose Garcia for the state, present and ready.
And David Nunez on behalf of Mr. Martinez, ready, Your Honor?
For purposes of the record, Mr. Angel Martinez is appearing remotely from the jail annex. We are set for a bond hearing today. Mr. Nunez, you may proceed.
Thank you, Your Honor. Mr. Martinez was arrested on April 5th of this year and has been in jail for approximately 171 days. He is 17 years of age. He is a U.S. citizen. He resides with his family on Alderete Drive here in El Paso County, Texas. His family consists of Hilda Martinez, his mother, and Osvaldo Martinez, his father. He does not have any kids of his own, and he is not married. As far as criminal history, this is his only arrest and has no other prior convictions. As far as education is concerned, he is a junior in high school. In terms of the nature and circumstances of the offense, Judge, according to the reports, Mr. Martinez is accused of attacking a female classmate with a knife while walking home from school. Bystanders, including the complainant's father, intervened, and the classmate was subsequently taken to the hospital. She was released from the hospital after being treated for multiple lacerations, which were approximately 1 to 2 centimeters in length. And yes, Judge, these are very serious allegations, but I think there's a lot of mitigating circumstances I would like the court to consider in determining whether or not to reduce the bond. First of all, I want to touch base, I guess, on the family relationship, Judge. Mr. Martinez's family and the CW's family, they were, or they are, I would assume, longtime friends. And up until recently, they were actually neighbors since Mr. Martinez's family rented out one of their homes to the CW's family, which was not too far from their home. I'd say approximately like 1 to 2 blocks. Mr. Martinez's father and the CW's father did maintain a close relationship even after the date of incident. But the CW's family did eventually end up moving out approximately, I'd say, 2 months ago. So keeping Mr. Martinez away from the CW will not be an issue if he is released. Another factor, Judge, is the mental health history and diagnosis of Mr. Martinez. And the case just essentially appears to be a result of an undiagnosed and untreated mental health condition. According to the 1622 mental health assessment in the court's file, it did indicate that Mr. Martinez suffered from major depressive disorder with psychotic symptoms. Since then, we did do a competency evaluation on Mr. Martinez, and he was diagnosed with, quote, unspecified schizophrenia spectrum and other psychotic disorder. The records reviewed by the evaluator and as well as the interviews that she conducted indicate that prior to the offense, Mr. Martinez was hearing voices. He did believe that there were worms in his head, and he was showing evidence of early psychotic symptoms. Since then, he's also taking medications at the annex. I do believe some of them are psychotropic in nature. And since taking these medications and I guess, and per the competency evaluation, Mr. Martinez's thought processes are now logical, linear, and goal-oriented, and he is not experiencing any residual symptoms such as hallucinations or any dangerous behaviors. If he is also released, Judge, the family has already scheduled an intake appointment at Samsara Healthcare here in El Paso County. It's located on Shirley Drive for a psychiatric evaluation and treatment plan as well. Regarding his, I guess, academic and personal background, Mr. Martinez was consistently an A and B student. He participated in the early college program. He also qualified for the gifted and talented program and had no disciplinary issues at school. These all come from school records that the state has already provided and then they're on portal. He comes from a supportive family. Both parents are actively involved in his life, and they're good parents. That said, Judge, I think it supports that he does have a strong foundation and could be an excellent candidate for rehabilitation if given the opportunity to do so. And he undergoes this medical treatment and for his mental health issues. Plans for Mr. Martinez if he is released from custody. We have spoken with his parents who do have an education and rehabilitation plan for him. And per my conversations with them, with his parents, YISD has confirmed that they're willing to accept Mr. Martinez into Cesar Chavez Academy, which is the district's alternative program, where he would remain for approximately 6 months before transitioning back into a regular high school. It would be different from where the CW, it would be Riverside High School, and the CW and him previously, they both attended Isleta High School. His mother is prepared to meet with
Mr. Nunez, but upon release, is he going to be living, aren't they neighbors?
No, Judge, they moved out approximately 2 months ago. So that should not be an issue. And then that being said, Judge, he's not a bad kid. He just has mental health issues that need to be treated. And by all indications, that's what it looks like to me. But that said, we are respectfully asking the court to reduce the bond amount to somewhere under $100,000, just to try to get Mr. Martinez into a mental health treatment facility while the case is pending. And that's all I have, Your Honor. Thank you for your time.
Yes, sir. I seem to remember, Mr. Garcia, that the last hearing we had the family here. Did we have them here, or I'm trying to remember?
Yes, Your Honor. Our last bond hearing was also on Zoom. The family was watching from the YouTube channel. They weren't exactly logged into the Zoom account, but they were watching from the YouTube channel. Yes.
Okay, so let me have a response, please.
I'm sorry?
A response? What's your response on the
Oh,
bond?
yes, Your Honor. And I hate to revisit the facts of this case, Your Honor, being that we went through this bond hearing again, but I'd like to remind the court, Your Honor, that we're talking about a complaining witness who was in high school at the time of this event. This happened in broad daylight. They were walking back from the high school to their home. Unprovoked, the defendant attacked her from behind, stabbing her multiple times in the chest, in the arms, in her back. She was left lying on the floor, Your Honor, while her dad, the complaining witness's father, attempted to rescue his daughter. The defendant also stabbed him. Your Honor, again, I understand that Mr. Nunez is saying that the families may have had a good relationship in the past and in the present, and that because she no longer lives in his block, near his home, he no longer poses a danger to her. Your Honor, I disagree with that. I disagree with the fact that this was unprovoked. This could have been anyone. He poses a danger to the community, to anyone who's walking near him, Your Honor. This was an attack that was unprovoked. It was her who was there. He attacked her from behind. He stabbed her multiple times. And yes, Your Honor, I believe he's still a risk to the community because of what he did. And for those reasons, I am respectfully requesting the court to deny any bond reduction at this point, Your Honor.
So the last bond order, Mr. Nunez, was it higher than $1 million?
No, Judge, I believe you left it where it's at because we wanted to do the competency evaluation. And that's what was filed. It had already been filed. It just had not been signed prior to the bond hearing.
Okay. Bear with me. I had not reviewed the exam report.
I think anyone has said.
I agree.
Yeah. Okay. So I am going to grant the request to reduce the bond. It is likely not, well, it is not what you're requesting, Mr. Nunez. I am going to reduce it to a $400,000 cash surety bond. The PR portion will remain the same. Miss Marissa, can you tell me if the PR bond order, no, I did the PR bond order last time. So that should have all the conditions on the PR portion. We'll just amend the cash surety portion at this time. Okay, so that'll be the order of the court.
Thank you, Your Honor.
Thank you very much.
May I be excused?
Yes, sir.
Thank you, Judge.
All right. Who's next?
Your Honor,
Judge, on page
Who is that?
14, on page 14,
Officer Perry from the jail, ma'am.
Oh, okay.
I wonder if at your earliest convenience, we could hear Quintana Brenda.
Yes.
She's got some disruptive behavior going on.
Okay.
Mr. Huffman, page 16, Judge.
Mr. Huffman?
Yes, I'm here.
Okay, let's take care of your bond hearing. Thank you, Annex. All right.
Your Honor, you're okay with Quintana?
Yes, sir. Yeah, Phil, but go ahead and bring her up, please. We have her attorney. I just wanted to make sure we had her attorney.
Just put it there, Ms. Quintana, right back there.
All right. Is that Ms. Quintana? Calling cause numbers 2024-0D06357 and 2024-0D00669. Each case style, the state of Texas versus Brenda Joanne Quintana. May I have announcements, please? Oh, I'm sorry. And 2023-0D08640. There's 3 cases.
Jose Garcia for the state, present and ready.
Rick Huffman on behalf of Ms. Quintana. I'm standing in for Brent Stevens.
And for purposes of the record, Ms. Quintana is appearing remotely from the jail annex. We are set for bond hearings in each of these cases. It looks like she is not booked on 0669. And so we have on 6357, $1,000 cash surety, on 8640, $100,000 cash surety. Mr. Huffman, you may proceed.
And Judge, thank you, Your Honor. My client's been found to be indigent. She certainly doesn't have that, the current bond. So I believe the bond is excessive. She has been found to be indigent. Your Honor, these are older cases, Judge. She did turn.
So let me explain. The gentleman that is speaking, Mr. Rick Huffman, he is an attorney with the Public Defender's Office. The Public Defender's Office represents you.
Thank you, Judge. Your Honor, if I can go ahead, she is a
Yes.
U.S. citizen from Tennessee. She's been in El Paso since 2016. These cases are older. They're two years old or so, and she got a warrant and she's turned herself in. She's been in custody for a couple weeks. She does have a house here with her mother, 79912 zip code. It's an apartment. She's currently trying to find a job, Judge. She does have a GED. Right now, Judge, she's getting services at UBH. It's my understanding that currently in the jail, she's not being treated for her mental health issues. She does have some significant mental health issues. Judge, I haven't thoroughly gone through all the cases. The assault on a public servant was at the UBH. She was in there for an emergency detention order, having an episode. And it's my opinion, Judge, that there are no injuries in that case. We do have a non-pros from one of the security guards there, not the other. Judge, we're hoping that she can get a bond she could afford, which is not much. Thank you, Your Honor.
Mr. Garcia?
So she has no bond at the time? Is that what I mean?
No, her bonds are 1,000 on the 6357 and 8640 is at 100,000. That has to be a capias.
Your Honor, and also I'd just like to correct something. The defendant actually did just get booked on the 0669 for 100,000.
Oh, thank you very much. Okay.
And both of the 100,000s were PR revocation cases.
Thank you, Ms. Nieto. All right, Mr. Garcia.
Yes, Your Honor. So I'm looking at her history. I do see an 11-page rap sheet on her, Your Honor. Most of it is assault, of the nature of the assaulting, Your Honor. Nonetheless, as Mr. Huffman stated, we do have a non-pros for the case here, and the other case here is not very alarming to me. I'm not opposed to a reduction of bond at this time, Your Honor. However, I would be opposed to a full PR. I believe maybe a 20,000 cash surety bond would be adequate for her at this time, Your Honor.
Has she been evaluated for competency?
Judge, I don't believe so. She just got rearrested and she's been in custody for a couple weeks, but I
I
don't.
am competent, Your Honor. I turned myself into these charges so that I may see justice for your system. And that is rude that you would accuse me of turning myself in unjustifiably when I personally came to your system to fix the problem I started here.
All right, so I'm gonna refer you to your attorney for any other comments. I don't want you to jeopardize your cases or the outcome of this bond hearing. Anything else, Mr. Huffman?
Judge, she's obviously denying these charges, and we're hoping that she can get a bond that she could afford. Like I said, Judge, she has been found indigent.
Mr. Huffman.
Yeah.
So Ms. Quintana, I'm going to ask you not to interrupt this proceeding any further. If you need to have an urgent meeting to speak with Mr. Huffman, we may be able to accommodate that over Zoom, but it will be at the end of today's docket. Mr. Huffman, do you need to do that before I proceed with a decision on the bond request?
No, Your Honor.
The request to reduce bond in these cases is respectfully denied. Thank you very much.
I want to take it to trial either way. For
You
like
have trial
January,
setting.
We'll
right?
talk to you, Ms. Quintana.
You have
get
trial
with you.
Claim guilty. I did
We'll get
that
with you
shit.
soon.
And I hope you
We'll be
did
there
that.
soon.
Okay.
Thank you very much. Let's go to the next defendant, please.
Annex, we could get Michael Luna for Mr. Vasquez. Page 14, Judge.
Good afternoon, Judge.
Good afternoon, Mr. Vasquez. Did your team win last week?
Tech did. Cowboys didn't.
Well, I didn't see you wearing blue. I saw you wearing red. So
Yes, Texas Tech is doing well this year.
Oh yeah, I wouldn't talk about a Cowboys game. We probably have a lot of Cowboys fans. I'm sorry, who is this?
Luna, Your
Michael
Honor.
Luna.
Okay, I
Page
pulled
14, Judge.
Lada. Okay. All right, calling cause number 2025-0D052, I'm sorry, 4228, State of Texas versus Michael Aaron Luna. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Your Honor, Joseph Vasquez representing Mr. Luna. Judge, 2 to 3 weeks ago, we had a bond hearing. He had 2 probation cases where he was facing revocations. The court entered $50,000 bonds per case. And then the following week, we had a hearing on a pre-revocation on his case. At that hearing, the state indicated that the complaining witness wanted to dismiss the charges and not pursue prosecution, and that she would not cooperate in the prosecution. So the court modified his probation, and the state was to dismiss the pending charge that is holding him, the $15,000 bond. That wasn't done. I did send an email to Mr. Garcia reminding him or asking him if it was going to be dismissed, and here we are. So
So I think they're looking at you, Mr. Garcia. Can you?
Yes, Judge, I'm reading the last note I have here. So we did speak with the complaining witness, actually very recently on the 16th. And she's indicating that she wants to continue with the case, Your Honor. Maybe that's the reason why I never filed a motion to dismiss.
So is this the gentleman, does this is one where we had a complainant?
he lives in
Carlsbad. Yeah.
and he came into town, and I
Mhm.
guess he had a date with the complainant, and she's alleging abuse. He's alleging that he didn't ask her out again, and here we are.
Yeah. Without going back and looking at without going back and looking at what transpired in court, I find it, because I do remember Mr. Luna's situation, I kind of feel like I would not have modified him on his probation cases if there hadn't been some type of assurance that the new allegation was going to be disposed of. But I'm not going to, hold you to that. My problem is I feel pretty confident that if the state had indicated they were going forward on the 2025 case, I know I was not inclined to keep him on probation. And so now I have a modification in 2 probation cases. And, right, order for release. Let me look.
Let me look at my previous notes, Judge.
Yeah, because I have him released to streets. Carla, was there any kind of modification in the works on Mr. Luna?
Your Honor, that's what I'm checking on right now, and I do have, this was on September 11th. We did have that hearing where Your Honor did request the modifications. However, I put a little star next to him. So to answer your question, I have not submitted the modifications because I was still trying to see if he was going to be released or not from jail because of the new case.
Okay.
So Judge, and I have here modify to BIP, and then I would dismiss.
Oh, so we're waiting on the mods? Is that really why we're all here at a bond hearing, is because we're waiting on modifications?
Well, I guess, Judge, he can't post the $15,000 bond, so we would respectfully request a reduction to $2,500 surety and whatever amount PR, and hopefully we can get the modifications done and he can get out and start BIP.
That's fine with me, Judge.
Your Honor, if I may, you had also ordered alcohol monitor
Mm-hmm.
and the no offensive contact on the
With the new
assault.
complaint. Mm-hmm. Okay, well, so we need the mods, right? I mean, geez. Okay, well, if the state is in agreement with respect to the bond, the court will reduce the bond to a $2,500 cash surety bond. But I mean, basically, if I go back, we're not coming back on the 2025 case, Mr. Vasquez, until November 20th, which I don't even know if we're here on that date. But anyways, November 20th. So you have an open case until then, until we see some mods and, you know, somebody needs to look at that so I can get a dismissal if that's what we're doing. All right, so there's your order on the bond. I need those mods ASAP to include the monitor. If memory serves, I think I also ordered that upon release, he had a certain number of days to get the monitor, all those kinds of things. So,
Yes, Your Honor, you did.
okay. So, Mr. Vasquez, your client keeps raising his hand, kind of.
Oh, I'm sorry. I was just 5 days, Your Honor, after I was released to get that monitor. I was just.
Okay.
Thank you.
Oh, and he hasn't been released yet.
And he was to remain in El Paso as well.
No, the judge indicated that he could return to Carlsbad.
I believe that's correct. Yes. And that's why I want the monitor on him, because I want the GPS.
Okay, if I may address Mr. Luna for him to report, I'm not sure at this moment if the case is still open in New Mexico or not, but he needs to come here to see the interstate office, so.
So what that means, Mr. Luna, is once you bond out, you will still be required, because they need to double check administratively that they will still supervise you in Carlsbad. So although I'm saying, yeah, it's all right to do that, there's a process. That process may take time, and it may mean that you will remain in El Paso County until such time that they have made the proper administrative checks for you to go. So
Yes,
until
ma'am.
the time you don't leave El Paso County, I'm
Yes, ma'am.
approving that if they will still supervise you, I will allow you to go. That doesn't mean you don't get the monitor. That means you got to get the monitor, and you're subject to all the other conditions.
Yes, Your Honor. Thank you.
All right. All right. Anything else?
No, Your
Can
Honor.
Sorry. Can I just get the bond? Can I get it one more time, Your Honor? Just
$2,500 cash surety on this case.
Okay. Thank you, Your Honor.
Already been released on the probation cases. So,
Yes, ma'am.
all right, Mr. Vasquez, anything else?
No, Your Honor. Thank you.
Thank you very much.
Thank you, Mr. Vasquez. Thank you, Garcia.
Ms. Nieto and Mr. Vasquez, so you know, out of an abundance of caution, we want to include a PR bond order on this. For if there isn't already a PR bond portion, it's going to be $1,000 PR. No contact whatsoever with the complainant to comply with all the terms and conditions of his probation in the other two cases, to include these recent modifications, the alcohol monitor, all of those things, just in case things want to go awry. Okay?
Yes, ma'am.
Thank you very much. All right, thank you. Who's next?
Thank you, Your Honor.
Judge, on page 14, we have Jorge Lara for Ms. Caballero. Alex, can we get Lara?
I'm here.
Wow, Ms. Caballero, I feel like I haven't seen you in a long time.
Well, Judge, it's because you haven't.
Oh, okay.
I
All
was down for a month and then I was on a vacation. And so this is my first week back.
Welcome back.
Thank
Mr.
you.
Lara, this is cause number 2025-0D05459, State of Texas versus Jorge Viela Lara. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Teresa Caballero, on behalf of Mr. Lotto, we're ready, Your Honor.
And Mr. Lara is appearing remotely from the jail annex. We are set for a bond hearing. You may proceed, Ms. Caballero.
Thank you. Judge, my client's been here for about 22 years. He is a resident. He went to Socorro High School, but he does not have a diploma. He lives with his wife. He has no children. His wife has been ill with cancer. Sorry, he lives with his wife and his parents. His wife has been ill with cancer for about 5 years. His address is 548 Nicholas Road, Socorro, Texas, 79927. And I believe the bond is $50,000. And he is not in a position to pay that. It's aggravated.
Is he a citizen?
No, my understanding is he's a resident, Your Honor.
Resident, got it. Sorry. Okay. I'm sorry.
And the way I understand this case is it was some run-in at a gas station, and my client's accused of running over the complainant. Except our position is that there was a serious self-defense issue. I think there might have been a case of bad bumper cars out there.
Okay. Anything else?
No, ma'am.
Mr. Garcia?
Very briefly, Your Honor, I don't think that he has other history other than this currently pending case. I did read the facts of the case, and I agree with Ms. Caballero. There are issues with the facts, Your Honor. Nonetheless, of course, the current pending charges is quite serious, and then I think there are multiple injuries that the complaining witness sustained. Having said that, Your Honor, I'm not opposed to a reduction of the bond. However, I would respectfully request that if it's kept at 50,000, the state will be okay with that.
Okay. All right. Yes, I have the PSR. I mean, we do have, some prior but nonviolent history.
Your Honor, the only thing I'm aware of is a vape pen charge, something like that of 2 years ago.
There's that. I mean, there was some immigration matter. Okay. So if the state is not opposed, what we're going to do is I'm going to split the $50,000. I mean, does he have resources for a bond?
Very few, Your Honor. I am retained, but that was a hardship on the family.
So where I am right now is I'm going to leave it at 50,000. I'm going to split it 20,000 cash surety, 30,000 PR to have no contact with I'm assuming it's only one complainant in this case. Maybe stay away from the place of business, which is that convenience store. Possess, subject to testing, use no illegal drug or alcohol. You're going to report once a month in person. You have to stay in El Paso County. You may not leave El Paso County or change your place of residence without court permission. Appear for all court settings and commit no new offenses. We need to come back. Please let me know. But for now, that's going to be the order on the bond.
We appreciate that.
Thank you very much.
Thank you.
Who's next?
Judge, on page 13, we have Mr. DeCotes for Kavika Johnson. Annex, if we could get Johnson.
Yes, sir.
Good afternoon, Judge.
Good afternoon, Mr. Dakota.
Mr. Garcia.
Hey, Mr. DeCotes.
All righty. Calling cause numbers 2024-0D04192, 2024-0D02454, and 2022-0D05140. Each case style, the state of Texas versus Kavika Rashawn Johnson. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Carl DeCotes for Kavika Johnson, ready.
For purposes of the record, Mr. Johnson is appearing remotely from the jail annex. We are set for bond hearings on each of these cases. You may proceed, Mr. DeCotes.
Thank you, Your Honor. The Honorable Court may remember Kavika. He was before the court about 2 months ago, talked about his UTEP football career, and he's on deferred for assault on a security officer, and that was since like 22, Judge. He's got a theft over 2,500 pending and a forgery of financial instrument. And we talked to the court about that. The theft was like a vacuum thing. He worked for like Rainbow Vacuums and they got their vacuum back. The forgery of financial instrument, I don't think he received any monies from those. The problem is, and Your Honor was kind of inclined to say, look, behave for a while and everything's going to go away. And we left very, very happy that day. I do think that Mr. Johnson had a drug test where he was positive for marijuana. My understanding is, I think he had like an edible for anxiety. Talked to the mom. We're hoping for any sort of relief. I think he's been in 3 weeks, Judge.
All right, give me a second.
Yeah. He also coaches kids football, Judge. Also want to say he turned himself in.
So he failed, let me see, I'm getting closer to August. He failed to report for July. He's been trying to move. Mhm. Mm. Oh, tampering, due to client had tampering device on August 11th. And he didn't want to take a test after that. So August 11th, yeah, they found him. So they had an invalid test on August 7th because the specimen did not register a temperature. And then on August 11th, the note invalid due to client having a tampering device. The client did not want to take a test after I took away the tampering device.
Yeah, Judge, and you would think you would kind of stay away from marijuana. I talked to the mom. They're from Hawaii, the islands, and they have their own ideas about things. But it's like, look, dude, you cannot do it.
So he's on no bond on the 2022 case. And then is he being held on the other two, Marissa?
No, Your Honor, he's only being held on the cause ending in 5140.
Right. So we have the, what are you doing? What, Mr. Garcia? What's going on with the new cases? What are you gonna do?
So Judge, so I'm hoping I'm reading this correctly. So as Mr. Coates mentioned, the assault happened in 2022. He was placed on deferred January 23rd of 2024. However, the theft happened June 2nd of 2023. And the forgery happened December 19th of 2023. Both occurred before he was placed on probation.
Right.
And I mean, if we could, I don't know what the agreement was initially when he pled, and he's on what, 2 years probation, so he still has 1 more year to go on probation. So I'm okay with I don't know, adding some sort of theft counseling and of course a TAP assessment for the positive. As long as he's doing okay on probation, we can get rid of these.
Miss Carla, are you there?
Yes, Your Honor.
I know what I mean, I see the recommendation. I mean, it's a long summary, which tells me that, you know, eventful, right?
Yes, Your Honor, I believe a lot of, and there were quite some violations or non-compliance, I should rather say, back in 2024. Mr. Johnson was in TAP for a moment. They discharged him because he wasn't complying. There was no testing. There were positives for marijuana at that time. He had left El Paso at one point. Then everything came up to the court's attention. I'm going back to 7/31/2024, one of our first hearings regarding all this. He got released, he continued on probation, and he did okay for a few months, and then the last hearing was in July 11, 2025. It was a Zoom hearing, and Your Honor wanted Mr. Johnson to be tested. That's when all what you reviewed right now happened from then until now, where he hasn't really tested. There were tampering. He does expire January 22nd, 2026. So in a few months, he does expire. So I know probation is wanting to have him screened for maybe substance abuse caseload, but he will need an extension as well.
Right.
We continue him.
The recommendation is a 6-month extension. What happened to Mr. Johnson? Is he here, Annex?
Annex.
Oh, okay. We lost our
Camera's off.
video.
Can you hear me, Your Honor?
I can hear you. I just can't see Mr. Johnson, so.
Yeah, the camera is messed up. Good night, Your Honor.
So.
May I
What
speak, Your Honor?
what are you gonna do with your new cases? You're set for trial next week? Is that right? You're set for trial next week, Mr. Garcia?
Right. I mean, we can do that, or we can do a 1244B on one as miss the other one. I'm okay with that. I'm not entirely concerned about the new cases. I mean, I do want to keep them on probation.
Okay.
May I
So
speak, Your Honor?
I don't mind, Judge.
and I just can't see you. Go ahead. Now I can see you. Well,
Your Honor, just with all due respect, I have nothing but respect for everyone here. I just want to say that I apologize for what I took an edible and I was wrong for that.
let me just stop you. Let me just stop you because here's what I'm thinking and I don't want you to say something that's going to make me think something different. So this is what we're going to do. So on the bond hearing, he's entitled to a bond because he's on deferred. That bond is going to be $20,000 cash surety. We're coming back next week, Mr. DeCotes. Final hearing plea deadline on Tuesday.
Yes, Your Honor.
I am inclined to follow the recommendation for an extension and to modify him to the substance abuse caseload.
And I'll dismiss in exchange of that, Your Honor.
Well, I don't think nobody was asking you to do that, but you can do what you want with cases. What I'm saying is there is still, some conduct here that is concerning for the court.
Understand.
So we'll see him on Tuesday, of course, whether he bonds out or not, and we'll resolve these cases. But this business about having tampering devices when you're getting tested, there's sanctions for that, right?
Yes, ma'am.
We don't
And I remember I talked with you last time.
That's okay. Let's talk on Tuesday. We'll see you on Tuesday. If you all think you have an agreement, be ready on Tuesday, okay?
Yes, ma'am.
Mr.
Yes, Your Honor.
Is that fine?
I hear you, Your Honor. So
Okay.
just for Mr. Johnson, if your mom wants to spend $2,000, or you can wait till Tuesday. Thank you, Judge.
Thank you very much. We'll see you next week.
Okay. Bye-bye.
All right. Who's next?
Judge, on page 12, Mr. Olivas for Emmanuel de Leon.
De Leon. EWI third. What's his bond?
I believe it's at 1,000, Judge, but don't quote me on that.
1,000?
Yeah, I think that's what I saw.
I'm sorry, who are we on? The phone
De
rang.
Leon. Emmanuel de Leon. No.
Is that correct? It looks like 10,000.
So 2025, and then, he's got
The bad word on
probation
here.
violation on the misdemeanor. So he's at
Right.
60,000 split here. See,
Right.
is that right, Miss Nieto?
Yes, I'm checking it, Your Honor. It's 12,000 on the misdemeanor and 60,000 split on the felony.
All right, so
And
20
this-
cash surety, 40 PR.
Yes, Your Honor.
Thank you. All right, calling clause number 2025 0D02335, State of Texas versus Emmanuel de Leon. May I have announcements, please?
Yes, Your Honor. Jose Garcia for the state, present and ready.
Jesus Olias, on behalf of Mr. De Leon, Judge, we're ready as well.
And Mr. De Leon is appearing remotely from the jail annex. We're set for a bond hearing. So I'm clear. I'm seeing these bond orders. He's at 2040 on the felony, but I'm seeing that other bond order. Was he on probation?
I don't,
No, he just had a misdemeanor pending.
that's what I can tell.
Well, he was on probation in 2018, but he finished that.
Yeah.
Okay. Okay. You may proceed on the bond, Mr. Olivas.
Thank you, Judge. My client's been in jail since the end of March of this year, Judge. Obviously, he's not been able to make bond. He was living at 1733 Challenger Lane here in El Paso. He's 37 years of age, and because of his incarceration, he's unemployed. So we're asking the court to lower it as much as possible, perhaps even a PR bond, because his family is really having a hard time coming up with any sort of funds to get him out. Yeah.
Okay. So why do I have, okay, on
Your
20,
Honor, I'm not sure he finished the probation.
yeah, no,
Because I see a motion to revoke in December of 2020, and it went inactive, the case, until March 30th of 2025, and then that split bond that's tied for the misdemeanor was put in on April 1st of 2025. I guess when he got picked up on the warrant. And so it is showing, and then I have the felony at 20,000 cash or corporate surety and 40,000 PR. They were issued the same date, April 1st, 2025.
Yeah, I mean, I'm concerned about the due diligence of the district attorney's part, that revocation. Yes, Mr. Garcia, don't give me those weird eyes.
Not me.
the motion to reveal, okay, well, yeah. Is this a true third?
Yes, Your Honor, it is a true third.
So he picked one up in he was convicted of one in 2015. He did 9 months on a DWI. And then we get the DWI in 2019.
1 year.
That was 14 months probation. 18 months? Because they amended the probation. And then they extended him in 2020. And that didn't work out too well because we got a third. Yeah, I don't see any others. I don't see any like out of state. Yeah. Anything else?
No, ma'am, that's all we have.
The request is respectfully denied. Thank you.
Thank you, Judge. Have a
Who's
good
next?
afternoon.
You too.
Bye-bye.
Judge, on page 12, we have Nicholas Harper for Mr. Huffman.
Hi,
Annex
Mr.
Harper. Also, Judge, on page 13, Jacqueline Johnson cannot appear because he's been transferred to federal custody.
And I think we're just on a status for that one.
Well, do we know?
I tried calling her yesterday, Judge. I wasn't able to. I guess they didn't let me talk to her because she's in federal custody. But
Do we have some kind of outstanding order, warrant or anything like that on Miss Johnston?
I don't know.
When did she go into federal custody?
I
believe it was recently, Judge, because last week when I did the docket, it wasn't on there.
There is a warrant, Your Honor. The motion to adjudicate guilt was actually just issued on the 18th.
And in terms of the 5260, does that have any kind of order?
Yes, a warrant issued on the 10th of September.
Okay. So, okay. I guess we can leave the settings as is on that one. Let's go back to Harper. Thank you, Marissa. This is 2024-0D05006, State of Texas versus Nicholas Harper. May I have announcements, please?
Costa Garcia for the state, present and ready.
Rick Huffman on behalf of Mr. Harper.
For purposes of the record, all parties are physically present in the courtroom no, they're not. Mr. Harper is appearing remotely from the jail annex. It was a long morning. We're set for a bond hearing, Mr. Huffman. You may proceed.
Thank you, Judge. Your Honor, Mr. Harper is a United States citizen. He lived in Dallas recently, but he moved to El Paso. He's been in El Paso for a few months. Judge, he was before arrested, he was living at the Opportunity Center. That is where this incident occurred, Your Honor. This is an alleged aggravated assault at the Opportunity Center. Your Honor, currently the bond, I guess Mr. Harper is a full-time student at LA Film. That program offers online courses, so he would be able to do that in El Paso. Judge, he's planning on resolving these cases and staying in El Paso and doing those classes. Probably not at the Opportunity Center, but we're hoping that he might be able to get into the rescue mission or a different homeless shelter until he gets back on his feet. Your Honor, he's reached out to family and friends. Mr. Harper thinks that he may be able to afford a $5,000 bond, and we're asking the court to consider that. Thank you, Your Honor.
Okay, Mr. Garcia?
Yes, Your Honor. Mr. Harper has a 31-page rap sheet. Most of the offenses are the violent nature, Your Honor, such as this one. The facts involve Mr. Harper holding a metal pipe, charging towards the complaining witness. Your Honor, I am opposed to a bond reduction for the safety of the community.
So the bond is 20,000 cash surety?
That's reasonable.
Mr. Huffman, well, I have my PSR is 43 pages.
Oh.
And it does have an extensive criminal history in and outside of El Paso, Dallas. Yeah, the request is respectfully denied.
Thank you, Judge.
Thank you very much. Who's next?
Judge, on page 14 for Mr. Huffman, we have Trevor Mower. Annex, can we get Trevor Mower?
Yes, sir.
All righty. Calling cause numbers 2025-0D05283 and 2025-0D05284, each case styled State of Texas versus Trevor Reed Mower. May I have announcements, please?
Jose Garcia for the state, present and ready.
Rick Huffman on behalf of Mr. Maurer.
For purposes of the record, Mr. Maurer is appearing remotely from the jail annex. We are set for bond hearings. Mr. Huffman, you may proceed.
Okay, Your Honor. I believe Mr. Maurer has a $20,000 bond totaling both cases. And he's been in custody for about 50 days. Your Honor, I think this is the first time he's ever been accused of a felony. He does have some prior violation of protective orders. I have not looked through those. I assume it's the same complaining witness. This is an ex-girlfriend, Judge. And I believe the new allegations allege he left some voicemails to the complaining witness. I've heard some of the voicemails, Judge. I don't find them threatening or harassing, but I mean, obviously the protective order includes a no contact provision. That being said, Judge, my client does promise to stay away from the complaining witness. He doesn't have any violent history, just the violation of protective orders. He's a lifelong resident of El Paso. He has a GED, lives with his dad in El Paso in Central. He's provided me the dad's phone number. He works as a landscaper and in restaurants. Wants to go to trade school for HVAC. Judge, we're hoping the bond is in the range of about $3,000. It's an amount that he thinks he might be able to afford through his family and friends. Judge, and he promises to appear in court. Thank you, Judge.
Thank you, Mr. Garcia.
Yes, Your Honor. I believe the bond to be reasonable because we have here 1, 2, 3, 4, 5, 6 violation of protective order, 2 of which he's already pled on. They have dates of September 25th, 2024, and a June 7th, 2025. So one is a felony, one's a misdemeanor. He pled on those on July 9th of this year. And after he pled on July 9th of this year, the following day, July 10th of 2025, he picked up a new one. And then July 18th, he picked up another one. And then July 24th, he picked up another one. And then July 25th, he picked up another one. So because of this repeated history and pattern of picking up violation of protective orders, not to mention they're all the same against the same complaining witness, Your Honor, and because of the safety of the complaining witness, we are respectfully requesting the court to leave the bond as is.
Can I respond briefly, Judge?
Yes, sir.
Yeah, I apologize. He was accused of a felony, a violation of protective order, and that was reduced down to a misdemeanor. So he doesn't have any misdemeanor convictions. Sorry about that, Judge.
No worries. Yeah, the bonds I'm showing at 5,000 on 5283, 15,000 on 5284. Each of those are reasonable in the court's opinion. So the request is respectfully denied. Thank you. Who's next?
Judge, we have two more, Adams and Rodriguez, but they are no longer, I believe, assigned to Public Defender's Office, and we don't have attorneys for them.
And I can stand in if we're still on, Judge.
I
for the
believe
bond
I
hearing.
signed the withdrawals and I
Mhm.
appointed before this, because Rodriguez, I know for sure, I already appointed someone else.
Understood.
We'll just have to reset them. Reset them so that we can have, I don't recall the basis of Miss Rodriguez's
I think one of them's a complaint.
conflict.
There is a conflict between the two. These
Okay.
two that we have left, there's some kind of conflict, Judge.
Yeah, we'll have to reset them with the new attorney.
Thank you, Judge.
Thank you very much. Appreciate your assistance. Annex, thank you as well. Thank you.
Thank you, Your Honor.
Who's left? Is it just us?
That's it, Judge.
Wow. All right. Look, both times I got you done before closing time. Thank you.
Thanks, Judge.
Have a good one.